He walked in with a file that was too organized for a case that should have been simple. I watched him set it on the table without looking at it. I watched him look at the young man sitting across from him, 18 years old, pressed collar, no record, with the specific calm of someone who had already decided this was finished. I had read the file the night before. There was a 3-minute gap in the location records that did not add up. I went into that courtroom knowing what was in that file and waiting to see what would happen when someone was asked about it. My name is Isaiah Webb. I am a federal judge in Chicago, and 5 years of sitting beside people who were on the receiving end of this kind of proceeding trained me to recognize its texture before the first word of testimony. If that kind of account, from inside the room, nothing softened, is what you came here for, subscribe and hit the bell. And before we go any further, write in the comments the one thing from what you are about to hear that you are going to stop pretending is acceptable. One thing. Because the record of what happened in that room deserves a witness. I am telling you this because that young man deserved one too. 4 years. I had been on this bench for 4 years when a prosecutor walked into my courtroom and said 3 words that I have not stopped thinking about since. I am going to tell you what those words were. But first I need to tell you about the room, what it looked like, what it felt like, and who was sitting in it. Because the 3 words mean nothing without the room. It was a Tuesday morning. Not the kind of Tuesday that announces itself, the ordinary kind, with flat light coming through the courtroom windows and the clerk arranging exhibits on the table with the efficiency of someone who has done this 10,000 times. The bailiff had called the session to order. I had taken my seat, and I was watching the door. The defendant, the prosecutor, entered from the left. I want to be precise about this. He was not the defendant in the legal sense of the word. He was the moving party. He was the one who had brought the charge. But from the moment he walked through that door, my attention was on him in the specific way that 5 years of public defense work trained me to pay attention. Not to the argument, not yet, to the person making it. The way they carried the argument before they opened their mouth. The particular quality of certainty that some people project when they have decided the outcome before the proceeding begins. He was organized. The file was too organized. Color-coded tabs on a case that should have required maybe a yellow legal pad and a clear conscience. He set the materials on the table without looking at them, which meant he had rehearsed the order. He looked at the young man sitting across from him. He did not look at me. He looked at the young man, and the look was not the look of a prosecutor assessing a defendant. It was something quieter than that, and something worse. It was the look of someone who had already decided this was finished. The young man was 18 years old. I want you to hold that number, 18. He had no prior record. He was represented by a public defender who was competent and exhausted in the way that public defenders in this district are competent and exhausted, doing the work of 3 people with the resources of half a person, managing this case alongside 19 others, present and prepared and operating at the absolute edge of what the workload allowed. The young man sat beside her with his hands folded on the table. He was wearing a collared shirt that someone had pressed carefully. He kept looking at the door the way people look at doors when they are still hoping that something will happen to change where they are. I had read the file the night before. I do this with every case, and I do it the way my clerkship trained me to do it, completely, from the beginning, with specific attention to the things that don't add up. There was something in this file that did not add up. A discrepancy in the cell phone location records. 3 minutes. The kind of gap that looks like a clerical error from a distance and looks like something else when you read it twice. I had read it twice. Then I had read it a 3rd time. I went into that courtroom the next morning knowing what was in the file and waiting to see what would happen when someone else was asked about it. What happened over the next 2 hours in that room is something I have thought about many times since. Not because it was extraordinary, because of what it revealed about a specific person and about a particular kind of belief. The belief that a position of authority is also a position of exemption. That the power to charge is also the power to define. That an 18-year-old without resources is a variable, not a person. I have spent 4 years on this bench watching what happens when that belief meets a proceeding that does not agree with it. This was one of those proceedings. The opening was confident. I will give him that. He laid out the charge clearly, the evidence in sequence, the timeline as he had constructed it. He spoke with the fluency of someone who had delivered versions of this argument many times and had not often been interrupted. The public defender made her notes. The young man watched. I listened. The alibi came in during the second hour. It was not complicated. A security camera at a convenience store 4 miles from the alleged location of the crime, timestamp showing the young man making a purchase at the exact moment the prosecutor's timeline placed him elsewhere. 2 witnesses who had been with him, a receipt, the kind of evidence that in a proceeding operating in good faith ends the relevant question immediately. The question of where he was at that time. That question had an answer. The answer was on camera. I watched the prosecutor's response. He did not question the timestamp. He did not challenge the camera footage. He challenged the witnesses. He questioned their reliability, their relationship to the defendant, the possibility that their recollections had been shaped by loyalty rather than fact. He did this methodically, the way you do something when you have prepared for it, when you have anticipated that this evidence would arrive and have prepared a response that does not engage with the evidence itself, but with the people presenting it. That is when I understood what I was watching. He was not trying to refute the alibi. He was trying to outlast it. He was betting that the combination of his authority, the complexity of the proceeding, and the limited resources available to the defense would make the evidence less credible than his narrative. He was betting, in other words, on the structural disadvantage of the person sitting across from him, on the 18-year-old with the pressed collar and the folded hands and the 19-case public defender. I have been on both sides of this kind of moment. That is not a credential I am offering. It is the specific context for what I am about to tell you. When I was a federal public defender, I sat next to people who were facing exactly this kind of bet. The bet that the system's weight would do the work that the evidence couldn't. I watched what it did to them. I watched what it did to their families. And I learned in those 5 years to recognize the specific texture of a proceeding where the evidence says one thing and the prosecution is asking the room to believe another. The texture of this proceeding had that quality, and I was not willing to let it continue without asking a question. I asked the prosecutor to provide the original cell phone location records, not the documents he had submitted into evidence, the originals, obtained directly from the carrier with the full metadata intact. He did not hesitate. That is the part I want you to notice. He did not hesitate, and he did not ask why. He said he could have them submitted. He said it with the smooth efficiency of someone managing a procedural request, not someone who has just been asked for something they hoped would not be requested. And in that absence of hesitation, in that absence of any visible concern, I understood something specific about what I was dealing with. He believed this proceeding was already over. He believed the weight of his position and the complexity of the process were sufficient to produce the outcome he had decided on. He was not managing a legal argument. He was managing a timeline. The original records arrived. I examined them on the bench. I want to tell you what I found, not to dramatize it because it does not need drama. It needs to be stated plainly, the way a fact needs to be stated when it is the kind of fact that changes what a proceeding is about. The records showed a gap, the same 3-minute gap I had identified the night before in the file documents. But the original metadata told a different story than the documents submitted into evidence. The documents had been, and I am going to use the precise word here because precision is what this moment required, altered. Not summarized, not excerpted, altered. A specific timestamp in a specific record on a specific date had been changed in the version submitted to this court. I set the records down. I asked the prosecutor to approach the bench. He came forward with the same composure he had maintained throughout the morning. I want you to understand what that composure looked like from where I was sitting. Not as confidence, because real confidence has a different quality. This composure had the quality of a performance that has run long enough that the performer has forgotten they are performing. He stood at the edge of the bench and he looked at me and he was still managing the room. I asked him to explain the discrepancy between the submitted documents and the original carrier records. I asked it quietly. The public defender could not hear me from the defense table. The young man could not hear me. It was a question asked in the register of someone who has already done the work of understanding the answer and wants to hear directly what the other person offers in its place. He told me he was not aware of any discrepancy. Those were the three words. I am not aware. He said them with the smoothness of someone who has rehearsed the sentence for a different context, a press conference, a deposition, a conversation that he controlled, and deployed it here, in this room, at this bench, as if the bench were that kind of room. It is not that kind of room. What he did not know, what he had not calculated, was that I was not asking because I needed his explanation to understand what the record showed. I was asking because I needed him to say, on the record, in my presence, with the clerk recording every word, that he was not aware of the discrepancy. That sentence spoken into the record of a federal proceeding is not a denial. It is a statement. And the statement, placed next to the records I was holding, was the completion of what I needed to know about what had happened in this case. I set the charges aside. I want to tell you what that means because I have seen the phrase appear in summaries of proceedings, and I have seen it read as a technicality. It is not a technicality. Setting aside the charges against this young man, in this proceeding, on the basis of what those records showed, meant that the case as it had been constructed could not continue. It meant that the evidence submitted had been compromised. It meant that the alibi, the camera, the witnesses, the receipt, was not only credible, but was now the clearest thing in the room. And it meant that I was going to refer the matter of the submitted documents to the appropriate oversight body. And I was going to say why, and I was going to say it into the permanent record of this court. That is what I said, all of it, in the courtroom, at full volume, in front of the clerk and the bailiff and the public defender and the young man with the pressed collar and every other person who was present in that room. He did not move. The prosecutor did not move. He stood at the edge of the bench and he received what I had said with the stillness of someone for whom stillness has always been a way of refusing to acknowledge that something is happening. But something was happening. The room understood it. The public defender understood it. The young man looked up from the table, and I want to tell you about that, about what his face did in the 3 seconds after I read the decision into the record, because that is what I have carried since. Not the prosecutor's stillness, the young man's face. He did not cry. He did not smile. He looked up at the bench with the expression of someone who has spent an extended period of time inside a situation they did not cause and cannot control, and who has just been told that the situation is over. There is a specific kind of stillness that follows relief that is too large to process immediately. It is not celebration. It is the body deciding slowly that it can put something down. I have been on this bench for 4 years. In those 4 years, I have made rulings that required a great deal of me. Rulings where the law and what I would have preferred to decide were not the same thing, and I decided what the law required. This ruling was not that kind of ruling. The law here was not in tension with what I would have preferred. What it required and what my conscience required were the same thing, stated in the same sentence, delivered into the same record. But I want to be honest about something. The fact that a ruling is clear does not mean it is easy. Clarity and ease are not the same thing. What was clear in that room was what the records showed and what the records meant. What was not easy was the specific weight of sitting at that bench, understanding what had been attempted in my courtroom, and knowing that the person who had attempted it was standing 3 feet away from me, with the composure of someone who had not yet decided to believe that consequences applied to him. I am not going to tell you what happened to him after that. That is a different proceeding, before a different authority. What I am going to tell you is what I believe about authority, after 4 years of exercising it and 5 years before that of watching it exercised against the people I represented. Authority is not a credential. It is not the title on the door or the position on the organization chart or the number of cases in the file. Authority is what you are willing to do when you are the only person in the room with the power to do it, and the person who needs you to do it has no other options. That young man had a public defender, a camera, 2 witnesses, and a receipt. What he did not have, what he could not have manufactured on his own, was someone at the bench who had read the file twice, identified the 3-minute gap, and was willing to follow that gap to wherever it led, regardless of who was standing at the end of it. I followed it. That is the job. That is the oath. Not the complicated version, the plain one. Do not let things happen in your courtroom that the law does not permit. When evidence is compromised, say so. When an 18-year-old with no record and an airtight alibi is facing a charge that should not have been brought, say so. Say it clearly, say it into the record, and let the record do what records are for. He walked out, the young man. His public defender gathered her files. She looked at me as she left the table, not with gratitude, because this proceeding was not about gratitude. It was about what happened in that room, but with the recognition of someone who has spent years doing this work and does not always see it end this way. I understood what the look was. I understood what it cost her to do this work. I have not forgotten it. I want to ask you something, and I want you to sit with it before you answer, even to yourself. Write it in the comments if you are willing. Write the one thing from what you just heard that you are going to stop pretending is acceptable. Not in the abstract, in your world. The one place where someone is operating on the assumption that their position exempts them from the rules that apply to everyone else, and where you have been deciding that it is not your problem to say anything. Write it. Put it in the record somewhere. It matters that it exists in writing, even here, maybe especially here. The cost of believing the rules do not apply to you is not always paid immediately. Sometimes the payment is delayed. But in my courtroom, in that room, on that Tuesday morning, it was not delayed. And the young man with the press collar and the folded hands went home. If what you heard today is the kind of account you have been waiting for someone to give, an account from inside the room, with all of it named plainly and nothing softened, I would be glad to have you here. Subscribe, hit the bell. Every person who subscribes to this channel is telling the algorithm that this kind of narration, honest, specific, from the person who was actually there, is what they want. That is not a small thing. That is what keeps this kind of account in circulation. He went home. That is the last thing I will say about this case, because it is the only thing that matters at the end of it. Not the proceeding, not the record, not the referral to oversight. That he went home. That an 18-year-old who had been fitted for a consequence he had not earned walked out of a federal courthouse on a Tuesday morning and went home. I carry that. I carry all of them. That is the job, and it is what the job should be.